Adams.
Mr Speaker, I move that the Returning Offenders Management and Information Bill be now read a third time. Mr Speaker, we've heard a lot about this legislation from yesterday afternoon and through today, but what I want to just come back to is the situation we're dealing with. We've heard a lot from the opposition that I think paints a reasonably misleading picture of how we've got here, but here's where we are. At the beginning of this year, we have been in a situation where for many, many years, serious offenders have returned to New Zealand without any sort of supervision or oversight. Now, I accept that as Australia changed their law at the end of last year, which took effect at the beginning of this year, those numbers have increased. But the fact is that serious offenders, murderers, rapists, child offenders, drug offences, violent offences, the full category, have been coming back to New Zealand for many, many years without oversight, without supervision. I first became aware of this issue and got advice from my officials on the 11th of February. I immediately instructed them that I thought New Zealand needed a regime to supervise these offenders, and the work has been moving since that time. So suggestions that somehow the writing of the bill is when the work is done represents a fundamental misunderstanding of the process. For those who haven't been ministers and who haven't been in this House, I can tell you that the work of putting together a new regime, the drafting is the very last piece. You have to start with understanding the implications on the agencies, how you're going to resource it, what the right balance is between Bill of Rights issues and safety and security issues, and to do that you have to know and understand the quantum and the nature of the people being returned. So I've said from the outset, we have to have this in place, let's get work underway to build it, but in the meantime we must conclude a better information sharing with Australia to make it work. I got it put on the Prime Minister's agenda at the end of February to raise it right up the agenda. That led to finally concluding the information sharing agreement with Australia, and I was always maintaining that that had to be in place before we could finalise this so that we could assess the impact on corrections, and I could stand and say quite confidently, we understand the resources required for corrections and police, we know the cost and we have resourced it. And I can say that to this House, Mr Speaker, because we've done that work, because we've spent the time getting police, corrections, justice, courts and their Australian counterparts lined up, knowing what we need and how it's going to work. This suggestion that you just rock up to the parliamentary drafters one day and say, write me a bill that says something, and the rest of the time was just fluff, frankly is absurd. It's absolutely absurd. This piece of work has been going at pace since it was first raised with me. That's more than the Labor Party can say when they had offenders coming into this country, serious offenders, all the way through their time in office and didn't do a thing. And frankly, I've been talking about this and putting out releases about the program of work on this throughout this year, and not once will they be able to point to a single statement, a single question from them saying, where is it, what's happening, or calling for it. The only person speaking about this year, about this issue and about the need to do it has been myself. And I've worked hard on it, I've delivered it at pace, but I've made sure we've got a regime that is fair to offenders, that balances their rights properly, that doesn't create a double jeopardy, but that still provides the monitoring and assistance that I think New Zealanders need. So now, 9 months later, we will have, when this debate concludes, a regime in place for the first time that supervises these offenders. And I'm very proud of that, because I know New Zealanders have been at risk from serious offenders in our communities without supervision until now, and that's what we're moving to address. Can I also just address the fact that somehow this is a knee-jerk reaction to the arrival that we're expecting later this week? Well, I can tell this House, if they follow the announcements I've made, which frankly they showed no interest in until they saw a chance to have a bit of a whack, I've been making announcements that this bill was progressing at pace, would be in the House this week and be progressed as fast as possible. The arrival of the offenders came after all of those announcements. So what we have, Mr Speaker, is now the conclusion of 3 pieces of work that I set up when I became, the issue was raised with me in February, a register to track and monitor these offenders that all of our law enforcement agencies can access, and as a single point of information, no matter where they are in the country, sharing that information. That's in place, check. An information sharing agreement with Australia so that when these people come back, we have good advice on their psychiatric state, their criminal risk, their behaviour in prison, their known affiliation, their criminal histories, anything we need to make a proper risk assessment and apply to the courts for whatever additional orders might be required. Having a regime where you could apply to the court for orders without that information would have been simply a piece of paper. You have to have the information. We have it. We now have the regime to go alongside it. Mr. Speaker, this regime is about putting in place the same sort of oversight that offenders would have expected had they been released from New Zealand prisons. No supervision regime will ever remove the risk. We are dealing with serious offenders, some of whom will reoffend, as offenders who are released from New Zealand jails reoffend. But what we can now be comfortable of and confident of, thanks to this bill, is that the offenders who come back to New Zealand who have only just been released from prison, not people who have offended long ago, the ones who have only just been released from prison, will be subject to the same sort of oversight, regardless of whether they serve that sentence in Australia, in New Zealand, or in some other country. And I think that's appropriate. It would make no sense to have to serve parole if you stayed in Australia, but not if you came back to New Zealand. So, sir, this bill fixes that gap. The last thing I want to make a comment on is the Australian policy that this is all about. I said in my opening contribution, we're not responsible for Australian law. We don't like the way this policy operates. We don't agree with New Zealanders who were sent or who went to Australia as very young children, potentially being removed when they have no ties to New Zealand. We don't like New Zealanders being held in immigration centres. But what we are saying is, while we can't change that, we have absolutely expressed our concern at those policies at the highest levels. Mr. Little is going to speak to Australian backbenchers. We spoke to the Prime Minister, we spoke to the Minister of Justice, we spoke to the Immigration Minister, and we continue to raise our concerns every single day. Every single time, not every single day, Mr. Speaker, every single time we get that opportunity. We don't like that, but at the same time, these people will continue to return to New Zealand, as they always have, and now, thanks to this National-led government, for the first time, we will be able to supervise them. Can I just make one final point, which is that while the numbers will go up and have gone up since Australia changed their law, a large number of that increase are not returning offenders. They have been deported on bad character grounds. About 40%, we understand. Furthermore, the extra part of the increase where they are offenders is because the Australian policy is now picking up much lower level offenders, as we heard the opposition members acknowledge. So when you're talking about that core of serious offenders, many of them were always deported back to New Zealand. They continue to be deported back, but now they will be supervised. They will be under probation. We will have the power to go to court and get orders to protect the New Zealand public because, Mr. Speaker, that is our primary goal. I commend the bill to the House with great pleasure.
Members, the question is that the motion be agreed to.